Okay, my Gen Zers, my Gen Xers, and my millennials. Sometimes in life, the bear eats you, and sometimes you eat the bear. Today was one of those days the bear ate me. If I can go back and talk to my younger self, I wished I could, I'd say, your losses are far more valuable, and your setbacks are far more valuable than your successes. Luigi Mangione. So many people have asked me about jury nullification. I thought I'd write a little prose about it. It may seem an apostasy for someone in my line of work, as a criminal defense attorney, to pontificate on what is such a delicate subject, but here it goes. There are far too many among us whose inner voice allows them to convince themselves somehow that United Healthcare CEO Brian Thompson had it coming, that somehow he deserved to be off because he was directly guilty of insurance coverage denial or was tangible proxy for healthcare industry, heartless industry that leaves its insureds out to dry. And if secretly rooting for Luigi Mangione, now charged with the most serious crime, is not enough, too many publicly protest the prosecution of Mangione or make deposits in his prison commissary to help fund his defense. We shouldn't then be surprised if Mangione's admirers somehow manage to steal their way onto a jury slated to try him for the most serious of crimes. Do we find ourselves in a new moment of a stealth juror? And if we do, what is the fallout for us as Americans? Featured centrally in the criminal defense lawyer's toolbox, honestly, is the determination to find the most effective method of prying open the deepest, most effective method of the deepest thoughts of jurors. That's what voir dire is all about. Particularly the elusive nullifier. Those jurors whose most intimate views motivate them to acquit a trial defendant regardless of the facts, even in the face of strong evidence of guilt. Of course, it is the prosecutor's duty to exclude them. My heresy notwithstanding, it is indeed the defense lawyer's righteous obligation to identify those nullifiers and try to seat them. There has been no time I can think of in recent history where the media has fixated on the arrest, prosecution, and the possibility of nullification lurking as a real potential threat for prosecutors in jury selection. That is the prospect of a defendant like Luigi, who faces what appears to be overwhelming evidence of guilt, escaping virtually certain conviction, when one or more of the nullifiers succeed in hanging a jury by deftly declining to follow the evidence and the law. Despite the growing mountain of evidence against Mangione, that holdout juror might calmly just drink their burnt coffee in a dusty jury deliberation room and explain to the other 11 angry men or women that I simply don't believe he did it. And you can't make me think he did, no matter how hard you try. That is, if the nullifiers even feel the need to utter any reason. So why is this scenario more likely with Mangione? Perhaps because he's young, perhaps handsome, fit, not unimportant in this context given the social media explosion on the topic of his physical appearance. He's a self-anointed gladiator, vindicating the public's belief that the American health industry steals from its insured by denying coverage for legitimate healthcare claims. The anger felt by so many Americans about their insurers' denial of claims has raised real concern in prosecutors and in mine that jurors may so sympathize with the motivation of the defendants on trial that, know what, they just vote to acquit him. And further, because the victim, given his executive role at a healthcare company, is somehow an appropriate representative to the industry, does it then follow he's an appropriate sacrifice? No. Make no mistake. Don't let any judge or lawyer tell you jury nullification is a thing, and it's American as apple pie. Courts recognize that juries surely have the power to nullify it, even though we all know it's not right. In this context, is understandable. Really, in Manhattan, a jury recently acquitted Daniel Perry for having caused the death by chokehold of an emotionally troubled rider on a New York subway car who may have posed a threat to other passengers. Some may posit that the Penny jury included the nullifiers, who chose to ignore the meaningful evidence against the defendant in response to now the sometimes dangerous New York City streets and subways. Penny has become a hero to some New Yorkers and even to the president, who invited him to the suite at the Army-Navy football game. But he emerges differently from those to be looking to fight like Bernard Goetz a year ago, or having a plan to off someone, allegedly, like Luigi Mangione did. But no one argues that the Penny's jurors were gone rogue, a bunch of wayward nullifiers. Instead, many New Yorkers, even those who favored the conviction, view the verdict as a result of citizens who quietly hope for Braveheart to have their back should they find themselves in a similarly situated situation. There is no argument citizens brought the common sense to that jury room as well as their life experiences. And theoretically, there may well have been a juror or two who wanted to be seated on the Penny case precisely to fulfill that. And here lies the difference between Penny and Mangione. That is the concept of a plan, detailed, comprehensive, philosophical, and diabolical motivated plan. And that is from the Lawfather, your favorite boomer, and your grandpa, is my answer, because I've had so many questions about jury nullifications. How'd I do with the green screen again? Pretty rad, right?